mentioning about the civil religion in abstract in the US, which you didn't have time to elaborate on. I was just wondering, how would you sort of compare, civil religion, as some of us know, was a concept popularized by Robert Bella, which had sort of provided the ethical foundation of sort of public policy. But there are sort of uncivil aspects of religion too in the US, as we are well aware. We know about the religious right. So could you sort of briefly compare the idea and how it's moved forward? And a very brief question for Professor Kotu. You talked about democratic profits, but sometimes, by definition itself, in religion and in profits, there's a strong hierarchy, and what the prophets or the priests say are sacrosanct. So there is a sort of undemocratic element to the idea itself. So if you could briefly elaborate on a little bit more on that idea of democratic profits.
Also, thank you to all those who've made comments previously. Again, I'm sorry I didn't have time to go into this very important model of a civil religion, which is the way I think the US and in some sense also France have responded to the same challenges of modernity. I like the idea that the opposite of civil religion is uncivil religion. I'm not sure that that's how the Americans themselves want to understand it. But of course, seriously, one thing that really actually struck me about the presentation of Professor Go is that this idea of checks and balances where government interferes, where, let's say, religious institutions themselves are expected to conform to certain political expectations. Of course, one thing which I think is deeply enshrined in most Western assumptions about the relationship between state and religion is that religions should themselves be largely independent in the way they organize themselves, and the country that obviously has tried to preserve that principle in the most extreme way surely is the US. So I think in response to your question, certainly an American would say, yes, there are all sorts of horrible things in a way are going on, but this is the price you pay for religious freedom. So we don't interfere at all. What we do is prevent any of this from being recognized as official government policy. So this is I think how that model of separation is supposed to work. So the state as such doesn't identify at all with any particular religious symbol. However, and this is I think where Bella is right, the state still, instead the state has created its own set of quasi-religious symbols, which you can see when presidents give speeches in the US and use a particular kind of rhetoric that clearly has religious overtones, even though it is not, at least not in theory, identified with any one particular religious or ecclesial or confessional tradition.
Okay. Judeo-Christianity had a head start in building up a modern democracy. Some people say that because it has this tradition of prophets and martyrdom, and in fact these two can be equated with each other. Most of the prophets end up with a very terrible results. But in retrospect, I think if we look at the history, American history, or other more recent cases like in the Philippines or Latin America, it's really the religious leaders, sometimes even the lay leaders of lay believers, who reinterpret the Bible, who cited frequently the prophets, to include ideas and to incorporate ideas of a liberal democracy. So I think this is very, very important, and it can be a lesson that all other new democracies can learn from religious leaders or religious scholars in the universities can initiate all this, what I call the democratic theology, and asking religious leaders to implement the democratic ideas in their organization. After all, I mean, they depend on our donation and the followership. And particularly with regard to Buddhism, since I'm very glad that I learned a lot from the local experience here, that we saw that there is some difference between the Mahayana tradition, Mahayana Buddhism, and what we call the Theravada Buddhism. And Mahayana Buddhism is, by current standard, is probably more democratic. And so, but again, the Buddhists in the early 20th century in China developed this humanistic Buddhism, and later on we also saw the engaged Buddhism going on around the Mahayana tradition. But we still have some problem with the Theravada tradition, which has traditional emphasis on the concept of karma king, and it's a traditional emphasis on the merger between religion and the state, and that's sometimes created problems here. Whenever a religion becomes a state religion, religious freedom suffers. Not only among religions, but also within the religion. We saw that in Judaism, when the Israeli state was established by Saul. We saw that in Catholicism in the 4th century, when Constantine made Catholicism a state religion. And we even saw that in Buddhism, when Ashoka established Buddhism as state religion. So I think there's something we can learn from all these great religions, that religion is to keep some safe distance from the state, but continues to exercise this checks and balances function to guarantee religious freedom. Thank you.
Thank you very much. Do we have other questions? Maybe I collect now, because we are now slowly running out of time. So please, if you have a question, give me a sign that you have one. More others?
May I ask one question to Professor Sukahara? If we look at the religion, like you say, that as a criteria to include and exclude the people, and also the politic itself as a tool to include and exclude people, we will see a very big conflict between Christianity and Islam. And as a matter of fact, if we look at crusade, on one point we can say it is the problem of the religious conflict, but on another side we can say it is also a political conflict. And at the same time we can say it is the conflict because of the route of trade. In order to gain the new route of trade, the Christian European political community have to break through and get fighting against the expansion of Islam. And let's say that the Western political communities had won this war in the 20th century after the falling of Ottoman Empire. And now it is the comeback of the new fighting and it is motivated by political interest, not the religious interest, but the use, or at least people try to use the religious identity again to include and exclude people. How do you look at this problem? And one another point I would like to ask you also, maybe to Professor Kua too. To my understanding, the main idea of Buddhism is not to exclude, but to include. And this is different. As Buddha said, we are not going to tell the others to practice our belief, or to push them away, but we will show, whether they will agree or not, it's up to them. And this is very weak exclusion in the weak idea of the exclusion in Buddhism. However, recently we observe some clash between the Buddhists and the other believers, like happening in Myanmar, that Buddhist groups even attacks the other religious groups and so on. What was cause? Is it religious, or is it more political, or it is a wrong interpretation and so on? Thank you.
Trying to develop in my own paper that this kind of unholy alliance between a religion and a political entity ultimately perhaps isn't really to the advantage of either of the two sides. I think using the term religion easily almost becomes a department of government, and so it's really difficult. It can become difficult, ironically we might say, for a religion that seems so privileged in a particular political settlement to get across its own particular religious message, because it becomes just so inextricably fused with the political interest. Of course, having said this, perhaps we shouldn't become too one-sided and merely, in a way, I've given into that temptation myself, become focused entirely on the negative sides of this. If we look at the periods in history, and I think that is true across cultures and across historical periods and across religions, if we look at periods where there have been close alliances between particular religions and nations or political empires, for example, these are often also the periods of incredible cultural achievements. So this is when perhaps the most impressive religious buildings were built, when the most marvelous religiously inspired literature has been produced, and so on and so forth. So I think we have to look at the bigger picture, and if we then say, as we've heard, the establishment of the Israeli kingdom was a problem for Jewish religion, or Constantine was a problem for Christianity, then I think we shouldn't forget that, of course, in some ways also these periods were periods of incredible flowering of culture, and so I think we have achievement and failure often really closely tied together. But anyway, I think I really agree with the perspective of your question. Thank you.
Religions can make peace and war. It really depends on how the religious leaders or lay believers interpret their scriptures. I examined some of the early sutras of Buddhism and found that the ideas promoted at that time, at the Sakyamuni's time, were very, very democratic. Sakyamuni emphasized equality, not just between the clergy and the lay believers, but also among clergy, among monks. And he said, I'm just one of the voices, and we have to make decisions together. Don't just listen to me. Okay? And then he also promoted the idea of a rule of law when one of his disciples asked him, after you die, if somebody comes and say he's a Buddha, how do we verify that? And Sakyamuni said that, well, you have to verify his sayings or his teaching against by the scripture, not by person. Okay? So there are plenty of democratic ideas. The question whether we can cite this original scripture, which have the most sacred values, to the current applications. Unfortunately, what happened in Sri Lanka, in Burma, and probably to some extent in southern Thailand nowadays, that some Buddhist religious leaders tend to emphasize the importance of the karma king, particularly with a new interpretation of the merit system. That if you kill a believer of other religions, then you earn the highest merit. That's, I think, is terribly wrong. So I think we should develop again this democratic theology based on the early scripture, and I found that most of the major traditions provide such room for reinterpretation, and that's consistent with the teaching of the major teachers. Thank you.
Thank you very much. Now we have to close, but if there's a very, very brief last question, you can raise it. I see it is not. So I will give the word back to the presenters for also, please, a very brief conclusion. Thank you.
Well, thank you for all the questions, and also thank you for your paper. I mean, one thing that became clear to me in the course of our discussion really is how careful we have to be when we look at this whole complex of, well, religion and politics in general, and in particular religion and political identity. In the West alone, almost every country is following a particular path, and then if we compare countries like Thailand or Taiwan, things become once again more complicated. Of course, we shouldn't therefore shy away from asking big questions and trying to discern general lines, but it is definitely the case that the way religion and politics are related depends in many ways of exactly not just what religion we have, but how it is interpreted, who the leading intellectuals or clerics are who are influential. It is also dependent on the state of the Commonwealth, on the competence of people who are influential there, of the competence of politicians or of lawyers. It depends on the state of development, whether we have an emerging nation or a political community that has been established for a long time. It probably depends on economic factors, whether a particular country is prospering or not. So in a way, we should shy away from, or we shouldn't certainly think that there is a sort of one-size-fits-all solution to the problem. And yet, I think it is clear to me still that religion and collective identity are related towards one another, and at the same time that there is a massive tension there, in that what can be a good thing can also produce massive dangers, both for the society, but also, I think, internally for religions that are concerned with this particular task.
I follow Johannes' argument that I think we should have more dialogue between religious leaders on the one hand and political leaders, scholars, particularly legal scholars, in order to help them to construct a democratic theology. After all, believers cannot participate in politics without the blessings of their religious leaders. And finally, in this dialogue, don't forget about political scientists.
Thank you very much to both presenters. I ask you for a warm applause for them. And after that, I close the panel and invite you to have a short break of only 10 minutes, please, because we want to keep our timeline. Thank you very much.
Okay, now we're having the second panel discussion coming up, and I would like to introduce Justice Slavica from Croatia. Very nice to have you here, and as well Theo Lian here from the National University of Singapore, and who is expert on religion and law. Yes, and the discussion will be Dr. Dukwang Lee, and yeah, so please.
Yes, thank you very much. I have the great pleasure and honor to sit here next to two distinguished experts, which we could read for this conference. Sorry. Okay, again. It's my great pleasure and honor to sit here next to two distinguished experts for our topic. I will first introduce to Judge Slavica Banic, because he's the first to read. Slavica Banic is the judge at the Constitutional Court of the Republic of Croatia, and at the same time she is a substitute member of the Venice Commission for the Republic of Croatia. Next to that, she is also lecturing at the University of Zagreb in public law. At the same time, she's also pursuing her PhD. I don't know how she does that. At all. But I'm very happy and pleased that we could make it again. This is the second time for Judge Slavica to be with us at the conference. Not only the conference, but also the winter school, which we completed yesterday. Now, it's my great pleasure to give you the floor, Slavica.
Dear colleagues, first of all, I express my deepest gratitude to CPG for another invitation to share my experience from Croatia and for enabling me another visit to this beautiful country. I named my presentation as a thorny path toward partnership because my focus was on the issues of legal recognition and acceptance of all religious communities within the Croatian society. However, in the course of this elaboration, it will appear that this thorny path was at the same time the winding one in favor of the most dominant religious community in Croatia, which is Roman Catholic Church, but also because of the fact that politics unilaterally did not hesitate to develop relationship which would procure support of religious communities in maintaining the political power. Still, in spite of this fact, that Catholic Church was favored and widely accepted, its partnership with the state is today more than ever on a thorny path. Position of religion, religious communities, and accordingly of the exercise of the freedom of religion in the recent history of Croatia could be divided in two periods. The period of the socialist regime that lasted from 1945 up to 1990, and the second one from 1991 until today. The first period is worth mentioning in the context of revitalization of religion and religious, which happened from 1991 and on when the religion took an important place in the following social development. Namely, from 1945 up to 1990, socialism conducted gradual but steady secularization of the Croatian society, which had carried a Roman Catholic feature before the Second World War. Religious communities in general were excluded from any participation in the social social development, were deprived of the property through nationalization, and in the socio-political context of that time, were considered as potential danger for the socialist political order. Although the socialist constitution established the right to freedom of religion, the system advocated atheism and pushed the exercise of the freedom of religion completely to the private domain of life. The affiliation to the respective religious community or any kind of the religious behaving was the obstacle for the public functions, whose consequence was the exclusion from the active involvement in political life. Over time, this rigid approach of the state weakened, and at the end of the 70s in the past century, the socialist regime enacted the Act on Legal Status of Religious Communities in 1978. Although this act showed a certain level of tolerance toward the religious beliefs and communities, religion and all connected to it was left again in the private domain of life. The religious communities acquired the legal personality status ex lege without any further procedural details on the consequences of such approach. The practical denial of freedom of religion in the past 45 years, due to the institutionalized contempt toward religion and all the religious, was suddenly, in the second period of Croatia's relation to religion, converted to its national embrace. Irreligiousness was related to communism, while religiousness to capitalism and Croatianhood. The process of revitalization of religion and religious was largely supported by the politics. Religion became a powerful political revitalization of religion and religious was largely supported by politics. Religion became a powerful political force in the way that the leading party of that time was performing its religiousness in order to obtain a larger degree of legitimacy. Distinguished Croatian scholar in this field, Vrcan, claimed that 90s were the witness of the political mobilization of a significant part of present religious traditions, as well as the witness of the political mobilization of religious symbolism of all three religions which were present in the former Yugoslavia. It was true. In the case of Croatia, the second period of the Croatian relation toward religion has started with the political mobilization of Roman Catholicism aimed in redefining the Croatian national identity. The Croatian national identity was built up on the politicization of the cultural differences, among which the most recognizable was exactly the Catholic affiliation. On the Croatian scene was happening the process of mutual affirmation. Religion became an important resource for politics, but at the same time politics became an important factor for the affirmation of religion. How the things went on, it's maybe the best to present by telling you an episode which happened in 1992 by the first Croatian president's oath. By the oath before the Constitutional Court on the loyalty to the Constitution, President arbitrarily added the words, "So help me God," although they did not belong to the legal text of the oath. President's discretional change of the oath text was legalized by the respective law in 1997, and ever since is a part of the presidential oath, regardless of the fact that the current president, for example, declares himself agnostic. So, after the fall of communism, a newly established political order stayed at the general principle of the secular state. The Croatian Constitution of 1990 provided that all religious communities shall be equal before the law and separate from the state. However, Constitution manifested the awareness of the importance of the freedom of religion and stated that religious communities shall be free, in compliance with the law, to publicly conduct religious services open schools, academies, or other institutions, and welfare and charitable organization, and manage them, and they shall enjoy the protection and assistance of the state in their activities. This blossom of religion in practice did not mean at the same time its legal framework, institutionalized legal framework. For a long time, the state has not provided the legal frame on the status of religious communities, which would be realization of the constitutional provision of the freedom of religion. The Socialist Act on Legal Status of the Religious Communities continued its legal life within the new political order in spite of the obvious inconsistence with the Constitution. This inconsistence lasted until 2002, when Croatia enacted the Act on Legal Status of Religious Communities, which finally actually was the effectuation of the freedom of religion. However, the perennial political support of the Catholic Church in Croatia resulted in the establishment of the special relationship with the Holy See. Croatia signed and subsequently ratified 4 concordats with the Holy See, 4 international agreements on the legal issues, safety of the Catholic believers, soldiers and police officers of the Republic of Croatia, on cooperation in the field of education and culture, as well as on economic issues. These agreements are part of the internal legal order and by their force are above the law. Croatia's ratification, Catholic scholar Eterović defined as historical happening with important ecclesiastical, social and political characteristics. In general, all of them foresee very burdensome financial obligations on the side of the Croatian state. Said by the simple words, Catholic Church carries the rights and Croatian state the obligations. The agreement on legal issues recognized Catholic Church in Croatia a public legal personality, which enabled its complete independence within the Croatian territory. Then, among the major commitments of the Croatian state is the introduction of the Catholic religious education in schools as the equal subject when and if child's parents decide to have it as a school subject for their child. The content of the program of religious education is authorized by the Church, but expenses related to it are on the side of the state. Religious teachers may teach only upon the mandate given by the Church. They enter the school without any procedure, and they enjoy the rights as all public servants. Then the Holy See actually took the obligation to establish the military ordinary in Croatia, equated with dioceses and led by the bishop, while Croatia took obligation to secure all material conditions necessary for its functioning, then to establish the proper seat of the ordinary, as well as finance all ordinary staff. When economic issues are in question, Croatia exempted Catholic Church from Croatian tax system and obliged itself to return to the Church all nationalized property during the communist time, or to have it exchanged by other property or pay certain amount of money for it. Furthermore, Croatia obliged itself to pay certain amount of money on a monthly basis for the proper functioning of the Church. The amount was agreed according to the percentage of Croatian citizens who considered themselves as Catholic. Today's statistics say that 85% of people who express their religious affiliation are Catholics. Since these agreements have been signed and ratified before the enactment of the Act on the Legal Status of Religious Communities in 2002, it meant that Catholic Church is exempted of Act's reach. Church scholar Eterović is of the opinion that these concordats were expression of the Croatia's recognition of Catholic Church as an equal interlocutor. Furthermore, he claims that by then, Croatia wants to be an open state which accepts the principle of subsidiarity, enabling the Church to contribute betterment of a man and social community. Just for the German colleagues, recently I read that scholar Eterovich has become the papal nuncio in Germany. Analysis of these concordats will definitely confirm the fact that Catholic Church in Croatia was not supposed to pass this thorny path toward partnership. On the contrary, there are strong reasons in favor of conclusion that Catholic Church acquired a privileged status within Croatian society. This conclusion does not relate only with regard to its position toward other religious communities, but also with regard to the impact of the agreements in the Croatian legal order in general. Being above the law and below the constitution, they have been producing legal effects which blur the dividing line between religion and the state. The best example for this I will give you through a brief overview of the case of the religious teacher who entered the high school within the church's mandate. He became public servant and acquired all respective rights, like any other public servant. However, teacher divorced civilly. The church withdrew a mandate and the school terminated his contract since he did not possess mandate anymore. He sued the school for the illegal notice and lost the case. So he submitted the constitutional complaint alleging the violation of his right to private and family life since he lost his work just because of the divorce. During the procedure of evaluation, the Constitutional Court came to conclusion that there are no precise regulations on the position, rights and obligations of the religious teachers, and that the state has no proper regulation of the religious education at all. Unfortunately, in spite of these obvious legal shortcomings, the court was not of the opinion that his rights were violated by the omission of the state to regulate properly this field, in order not to bring the separation of the state and religion in question. So he lost the case even by the Constitutional Court, with two voices against. One of them was mine. I thought that his rights were violated, but thought that he did not act fairly in the procedure, and he deserved only the establishment of violation without possibility to ask the renewal of the process. So considering the fact that Catholic Church in Croatia achieved a high degree of independence with the Croatian legal order, my question is, what was the position of other traditionally present, known or newly founded religious communities in Croatia? How did politics behave toward other religions, and was it fully in line with the constitutional principle that all religious communities are equal before the law? The answer has been partly already given, so I will give you just a few remarks. At the first sight, the Act on Legal Status on Religious Communities from 2002 showed that it contained many freedom-like provisions. In many aspects, it followed the patterns from the international agreements with the Holy See, which were enacted 4 years before this Act. With regard to registration and of evidence of religious communities, it is rather open and balanced. However, with regard to the realization of the rights, the Act actually set up a barrier for their implementation. Namely, realization of the rights provided by the law depended on the agreement which should have been signed with the government. At the beginning, government signed several agreements, but being overwhelmed by several different religious communities' requests to conclude these agreements, in due time, it imposed conditions which had to be primarily fulfilled for it. So they were given with the governmental act which did not fall into the area of bylaws. Shortly said, the legal obligation to conclude the agreement was discretionally converted to the government's right. So only those religious communities which fulfilled the conditions set up by the executive discretion could realize their legal rights. Several religious communities could not respond to the asked conditions and then asked the Constitutional Court to review the legality of this act. Unfortunately, the Constitutional Court rejected the proposal, explaining that the act on conditions was not a bylaw and in that regard was not eligible for review. These religious communities continued their legal life and ended up before the European Court on Human Rights, which established the violation of the Article 14 in connection to the Article 9 of the Convention. In the justification of the violation, the court started from its fortification that state had a duty to remain neutral and impartial in exercising its regulatory power in the sphere of religious freedom and its relations with different religions, denominations, and beliefs. The court found that government's treatment toward the religious communities in question did not have any objective and reasonable justification. So the latter is clarification for my previous questions. Religious communities in Croatia, except Catholic Church, of course, were for a long time in the shadow of the state's relationship with Catholic Church. Alliance of the politics and Catholic religion, conditionally said, already in the beginning of the Croatian independence, contributed to stagnation in the development of multicultural society, which evidently had a negative impact on the smaller religious communities. The lack of legislation could be regarded like the state's ignorance on their development or functioning. The objections of smaller religious communities on the difficulties to exercise their constitutional rights were ignored. The programs for religious education of all other religions are approved by the respective ministry, which is not the issue with the Catholic Church. Imposition of the severe conditions by the discretion of governmental act was aimed to impede the religious communities on realization of their rights. Furthermore, state aid depends very much on the state's discretion on their contribution to the society. So the judgment of the European Court of Human Rights seemed to have opened the eyes to the Croatian state on the need of a different approach to the freedom of religion. But what about Croatian Catholic Church? We saw that it did not and does not share the destiny of the rest of religious communities. We also saw that politics was the main driver in its revitalization. It is evident that Catholic Church was given opportunity to take part in desecularization of the society. The four concordats are clear confirmation of this opportunity. They deeply affect the state by reshaping their secular institutions. They return Catholic Church to the public sphere. They enable resurgence of religious beliefs and practices and allow to the Catholic Church to reassert its social influence. It was more than sufficient legal basis for building up the partnership. However, I fear that Catholic Church in Croatia, in spite of this privileged legal and social status, has been still on a thorny path toward partnership with the state. Distinguished Croatian scholar Banac, in his book Croats and Church, deems that in spite of many dilemmas, the Church has remained the main moral arbiter of the Croatian society, regardless of the fact that Croats themselves, as well as the Church, were many times on both sides of modern divisions. If this is true, then I dare to say that the Church had open hands for reassertion of its social influence and its partnership with the state. So when and how this path has become a thorny one? My answer will have to return to previously mentioned position of the Church back in the 90s. The return to the public scene the Church has made with help of the then leading party, which was at a certain point of time seen as symbiosis of the state and the Church. The Church became present in all events, like highway construction, schools, preschools, buildings, were blessed by the Church priests. The politicians of the highest rank were present and all major Christian events or messes. Many distinguished sociologists and theologians deemed that the Church at that time developed a certain client relationship toward the leading political party, which contributed to the loss of the Church's institutional reputation and supra-party status. As much as the Church tried to be critical, the shadow of the flirting with the leading party became a constant burden in Church's objectivity. The Catholic scholar Tanjević admitted that the Church, after perennial isolation, did not meant the best in the understanding of the role of the state and of the society back in the 90s. The church projects that have a good cause sometimes fail because of unilateral, narrow religious aims. The church advocated the ban of the work on Sundays. It was exactly what Professor Kitisak talked about, ban of worshipping consumerism. So the aim was in improving the family life because most of working populations on the Sundays in shopping malls were women. However, next to this aim was the objection for non-worshipping Sunday as a date for mess. So the influence of the church was strong enough to have brought to the enactment of the Act, which was abolished by the Constitutional Court due to severe violations of the right to the equal opportunities of the entrepreneurs. The next barrier to the reassertion of social influence might be exactly these international agreements with the Holy See. They were seen as the cause for the church's alienation from the society, since it was more oriented in return of their property and not in a resurgence of beliefs. Recently, we have been introduced to the amount of money that is given to church. Around 30 million euros per year goes to functioning of the Catholic Church in Croatia without any justification from the side of the church. In the public, there are numbers which talk about 130 million per year, when all obligations of these agreements are uncounted. Very general and burdening financial clauses in concordats raise skepticism. In spite of the fact that all of them contain the clause on possible change of the agreed clauses, there is no impetus for this up to now. In the time of the overall economic crisis, which is deeper and deeper in Croatia, there are more often opinions in the public that the church does not share the destiny of all in the state. So the church and the state at this moment pass a very difficult period. Croatian society has been in process of re-examination of its values. Are they closer to Christian values, ethics and moral, or are changing in accordance with views of liberal society? The issue of sexual education at schools upset a huge part of parents due to some of the unacceptable parts which infringed their ethical and moral stance. The church stood behind them. The decision of the ministry failed by the Constitutional Court because of the lack of democratic pluralist procedure in issuing it. The disputes of the rearrangement of religious teaching at schools is seen as the attack on church and not in the interest of the children at schools in general. Of course, this is the statement of the church. The most recent and very hard problem is the constitutional referendum on the definition of marriage as union of a man and a woman. The initiative in the name of the family, strongly supported by the church, has been accomplished a decision of the parliament to conduct the constitutional referendum on this issue. The church uses the altars to promote the voting on it. In this relationship, the church carries the burdens of its sympathy toward the right-oriented party, and the current power expresses typical secular behavior. The result of this is a lack of dialogue and mutual understanding, respect and appreciation. The church expects from the state to respect traditional family values and opinion of the majority, which expresses itself as religious, while the state is decisive in running the politics on its own way with justification of taking Croatian society to the full democracy. The problem on the side of the state that it does not want to admit that Catholic Church in Croatia enjoys a high percentage of trust among the citizens. 48% of them claim that they trust the church at the first place. So this should be a starting point in reviewing of own attitude toward it. On the other side, Catholic Church has to accept the fact that Croatia is not an isolated island in Europe or the world, and that their values adapt to the social needs as they develop. Ladies and gentlemen, distinguished participants, I thank you for your attention, and I would use here a sentence from George Bernard Shaw, who once said for a lady, that she lost the art of conversation, but not, unfortunately, not power of the speech. So I hope that our further discussion will exempt me from this sentence. Thank you very much.
Thank you very much, Judge Banish, for your highly interesting overview over the history of the relationship between church and state in Croatia. Before I comment a little bit on your paper, I would like to give the floor to Professor Theo Lian. And Professor Theo Lian is teaching at the National University of Singapore. She's an expert on constitutional law, human rights, I will continue. Sorry for the interruption. As I said, Professor Theo Lian is teaching at the University of Singapore, and she's teaching constitutional law, religion and law, human rights, and international law with a special focus on Asia. She has published widely in all these areas, and I would like just to mention two latest publications. First of it is the Constitutionalism in Illiberal Polities, published in the Oxford Handbook of Comparative Constitutionalism, and the second is Relational Constitutionalism and the Management of Interreligious Disputes. So we're happy to find quite an expert on the relationship between state and religion. Professor Theo Lian, the floor is yours.
Thank you very much. Thank you first to CPG for this very kind invitation. I'm always very excited to speak on religion and state because it's very hard to find people who are interested in this topic, but it's good to be in a room of like-minded people. The title of this conference is Religion and Communities, Political Communities, Partners, Competitors and Aliens, ? Maybe it's all three. And coming from a Singaporean, we tend to espouse a brand of principled pragmatism, which will tend to upset the logic of Germans anyway, but it shows that we are able to coexist with ambivalence and inconsistencies. So what I have done is entitled my presentation Control, Conflict, Control and Cooperation, which suggests both a positive and a negative relationship with the state. So the Singapore model of religious freedom may be called the secularism with the soul model. And again, this is deliberate. I did not coin it. This was coined by one of our Muslim ministers a couple of years ago. And it juxtaposes the metaphysical and the material and talks in terms about the ability of liberal secularism and religious affiliation to coexist. I might also add that in terms of constitutional design, there's a fascinating array of state-religion models in the Asian context. And I might also add that there's nothing in constitutionalism which is about constraints on arbitrary power or people. There is nothing in constitutionalism that requires metaphysical skepticism. I think that's extremely important to understand, particularly in the Asian context. So as far as Singapore is concerned, you will find that religion is at various times treated as a source of public values, as well as there's competition against that, as well as a threat. It is both seen as a good and a bad, and it's basically a managing process. We in Singapore don't like to talk in terms of resolution. We don't believe resolution is possible in this lifetime. So, between apology and utopia, we are satisfied with management and peace. I will also add from the outset that in understanding Singapore, there is a very close conflation of ethnicity and race, and there has been in the history of Singapore ethnic and religious clashes and violence, and that seems to govern very much the current political leadership, because trauma always affects us, And religion has caused a certain degree of trauma in the Singapore context, and there have been very interesting responses to that. One last thing. In the year 2009, our Prime Minister Lee Hsien Loong basically called Singapore a Garden of Eden state. And he said this is because there is a conscientious management of the conflicting interests. But we all know there is a snake in the Garden of Eden, and therefore, even though religion is talked up as a constructive social force, there is always a fear that will spill over into as a source of social harmony and dissension. While in liberal constitutions, jurists may take rights seriously, following Ronald Dworkin, in the Asian context, religion is taken seriously, and that will certainly pose a challenge to liberal premises. So, straight to Singapore. We are constitutionally a secular state, but we are a religious society. Over 80% of Singaporeans adhere to some religion. The majority group is the Buddhists, who are always conflated with the Taoists, even though these are distinct things. The rest would include Christians, Hindus, agnostics, and those of other religions, Jews, Zoroastrians, etc. I might note that the Muslims are a very significant ethnic and religious minority, and they have special constitutional protections, largely because of the history of the region, which I will go into. So when we are dealing with the management of religion and state, at least in Singapore, we are dealing with a multi-religious society. And one could argue having an established religion of any sort is bound to cause any religious minority to be a little bit insecure. So for that reason, Singapore does not have an established religion. So the brand of secularism we practice in Singapore may be considered to be a form of anti-theocratic secularism, in the sense that political authority comes from the constitution and from elections, rather than from any divine text or sacred mandate. What is rejected in the Singapore context is what might be called an anti-theistic or fundamentalist secularism. Alright, that's just someone saying secular fundamentalism is bad. So we firstly have no official religion, secondly, no anti-establishment clause, thirdly, some legal pluralism in the constitution with respect to the Malay Muslim minority, and lastly, the kind of constitutionalism we practice may be described not as collectivist but as communitarian, which means that we don't just have rights to the exclusion of everything else. We balance rights against competing rights, against duties, and against public goods. In that sense, you can think of the government's great desire to try and construct a collective identity in a very plural society. If you are a European, you have years and years of history. I believe the Croatian constitution dates back, the preamble starts in the 8th century or something like that. So I actually used Croatia in my introductory lectures. Whereas in the context of Singapore, we have no shared history. So the only way to propel the nation forward is to try and construct a shared future. So it's almost Swiss in the sense that the commitment is to ideals rather than to any religious faith, but not necessarily to liberal ideals, but to communitarian ideals. So in this sense, it may be considered the Asian version of Habermas's constitutional patriotism, an attempt to create some kind of identity to kind of gel a very, very disparate nation. So to truly understand Singapore, Singapore's genesis, if you like, is rooted in its exodus from the Malaysian Federation. Yes, it's deliberate. Singapore was never meant to be independent. The British always planned that Singapore should be part of Malaysia. So today we are known as an accidental nation. We have survived for almost 50 years, still going strong, hopefully. So basically the idea is this. When Singapore peacefully seceded from Malaysia in 1965, our Prime Minister said, okay, this inaugurates 2 experiments being carried out into 2 places. And the reason why I'm focusing on this is because it is impossible, in my view, to understand Singapore apart from understanding its 2-year tenure in Malaysia and its adversive constitutionalism. The Singapore model of religion and state is adverse or averse to the Malaysian model. I think this is a deliberate rejection of the Malaysian model. This is one reason why Singapore was eventually expelled peacefully from the Malaysian Federation. So this is why. Firstly, there was a departure from the Malaysian model of having an official religion. Article 3 of the Federal Malaysian Constitution recognizes Islam as the religion of the Federation. Other religions may coexist. You will also notice that pursuant to the fact you have a confessional constitution is the fact that the state can allocate budgets for Islamic educational institutions and Islamic studies. We don't have this in Singapore. The problem with this, of course, is this. In the 1950s, when Article 3 was being drafted, it was considered an innocuous ceremonial clause. Nowadays, through a spate of judicial revisionism, there are sectors in the Malaysian society that argue that it should be considered, Islam should be considered a form of substantive public law. So this is an interesting tension that's ongoing in Malaysia presently. You will find that in the Malaysian mindset, at least, there is a great distaste for British colonialism, because the advent of the British common law was seen to introduce secularism and to roll back Islamic law. Because by Islamic law, I mean that the sultans were both religious and political leaders. They applied Islamic laws to Islamic subjects. But of course, Malaysia, like Singapore, is an immigrant society, so this was part of the constitutional bargain to, if you like, placate the minorities, that you could have Islam in the constitution, but it should be ceremonial, it should be given a higher status, but it should not mean that it's part of legislation and general law. So when Singapore was kicked out, you will find that from the outset, people often say Singapore is pragmatic, which means it's concerned with last things and not first things. I don't think that's true. The model I would prefer is principled pragmatism, because on methods of religion and state, I think there's quite a fair bit of principle. If you look at the proclamation on Singapore, which is Malaysia saying bye-bye to Singapore, it invokes the Muslim God. If you look at the proclamation of Singapore, which is Singapore embracing adulthood, it does not at all contain any religious references. It only refers to democracy and a more just and equal society. Right from the outset, and we must understand that Lee Kuan Yew had a pivotal hand in shaping Singapore. You think about it, he is Singapore's founding father. He's still a member of parliament today. He is rather old, but he's still, going strong. But true to his Cambridge-trained lawyer, true to his pragmatism, he said, we will trade with everybody, and we will not have an established church or state, established religion in Singapore. But one of the things they did do was, in lieu of calling a constituent assembly, they called a constitutional commission in 1966, with the express purpose of finding some kind of protection for ethnic and religious minorities. You look at parliamentary debates in that era, it said a nation based on one race, one language, and one religion, when its people are multiracial, is one doomed for destruction. So it was always into religiosity and multiracialism. As I said, Singapore does not have an establishment clause like the American Constitution, which permits the state to financially, if you like, and support at least the Malay religion. Secondly, the Malay constitution actually defines Malay as a person who professes the religion of Islam, which is the constitutional assignment of a religious identity to a person. In Singapore, the model of religious freedom is predicated on a voluntarist liberal conception. So insofar as the word Malay is defined in the constitution, the criteria used is anyone who considers himself a Malay, who is accepted as a Malay by the community. So there is no constitutional, you can theoretically be an ethnic non-Malay and a Malay if you are Muslim and you speak Malay. Okay, so as far as Singapore is concerned, there is no constitutional assignment of religious identity. Thirdly, as far as the Malaysian constitution is concerned, you will find that there are special Malay privileges, because there was argument that it was a Bumiputra privileges, which means sons of the soil, special rights for the ethnic group. So they have special rights in terms of contracts, reservations, etc., and state support when it comes to religious bodies. As far as Singapore is concerned, there is a constitutional duty on the part of the state to protect racial and religious minorities, and specifically Malays as the indigenous people. So whatever protection accrues to Islam does not actually accrue to Islam, it accrues to Malay. Because in Singapore, 99.7% of Malays are Muslims, only 0.3% are of another religion or of no religion. So there is a almost perfect conflation of ethnicity and religion, and it's taken as something everybody accepts. The constitution itself also requires the legislature to enact a law to deal with Islamic affairs in relation to a limited scope of family law, personal law, evidence law, things like that. And thirdly, you will find that the Singapore model of religious freedom is more liberal in terms of religious propagation. In the context of Malaysia, the various states can enact laws which restrict propagation of any other faith to Malays. In Singapore, this was debated by the Constitutional Commission and rejected because they said in a democratic secular state, we can't give preferential treatment to any religion. So you will find that every person has the right to profess, practice and propagate religion in the Singapore context. So obviously in the context of Malaysia, you will find there are great problems in the case law with issues of apostasy. When a Malay Muslim wants to convert out, in Singapore, our highest court has said, no, this is based on freedom of conscience. This is the same point. So you can see that Singapore basically defined itself in opposition to Malaysia, but even though there was a constitutional right to propagation, there is still the prudential soft law side of things, where as early as 1965, our Prime Minister said to the Christians basically, you can try and convert all the agnostics, but don't touch the Muslims. Because if you think of minority issues, it's bound to upset Malaysia, possibly Indonesia. Right? So you may have the law on one hand, but you must consider what's being said on the other hand in terms of what I like to call constitutional soft law. It's not legally binding, but it's meant to shape expectation and behavior. So Singapore is a secular state. When we defined our shared values white paper, you see in new countries like Indonesia and Malaysia, there's always an attempt to have some kind of patriotic statement of our values. In Indonesia, it's Pancasila. In Malaysia, it's Rukun Negara. So Singapore has the shared values, and it was considered, why don't you put in belief in God? And they said basically, our version of secularism doesn't allow us to do that. So we're going to exclude it. Singapore will have no reference to God in the constitution. Right? But the government says very clearly that we won't be antagonistic towards religion. So here's an example of religion and public life. You will find that religion is celebrated, at least in the celebrations. I mean, it's a good tourist trap, right? But basically the idea is that you want to celebrate your faith publicly. That's not an issue. We have Thai-Muslim processions. And in 2011, we had the first public lighting of a public menorah in Singapore. So the Jewish community was very pleased with us and said Singapore is an amazing place for religious harmony. People like to criticize my country a lot, so this is one positive thing being said by a religious minority within the state. You also find that there is an informal group called the Interreligious Organization, or the IRO, and they always come up when there's a public event. They will come in their Buddhist robes or the various religious accoutrements, dress, and they'll stand side by side. And this may be a bit of a setup, but it's symbolism. And symbolism is extremely important in Singapore because it suggests unity in diversity. Our religious leaders, I was very interested to see the slides in Taiwan and Croatia, all the politicians going there to seek the blessings of whoever. In Singapore, when we have national disasters, the tsunami of 2004 or plane crashes, you will get all the religious leaders on stage in their religious dress and the politicians off stage, and they will help nation mourn. This is very distant from the Canadian response to 9/11, where my understanding is they banned religious people. They wouldn't allow them to say prayers, which we in Singapore would consider very militant and not a good model at all. Right, this is very, very recent. Our Prime Minister attending a Buddhist festival. And it's interesting because there are rules against the mixing of religion and politics. But obviously, it's okay for religious leaders to be seen at general religious events, even though they do not invoke religion in politics. Not as blatantly as in Taiwan. In Singapore, that would be considered verboten. Right? You're not to appeal to religion, you appeal to the common good of everyone. Alright, so as far as religion is concerned and democracy, and in terms of the participation of religion in politics, the government has assured the religious people that we know religion is for many the source of morality, and we do not actually ban you or not against religion, we uphold sound moral values. It's not possible to divide a person's brain into the secular and religious half. So what they said is this: the government is fair, but the government is not going to take any sides. There are many religions and they compete. The function of the government is almost procedural. It holds the ring, it allows other religious groups to coexist. Now they have absolutely no problem with individual citizens with religious affiliation from participating in great debates like the casino or gender identity politics or anything like that. But they do have a problem with religious leaders and possibly religious groups. They don't mind the atomic individual speaking up, but they're a bit disconcerted when someone who can control 10,000 people speaks up and is able to wield influence. In fact, what is very amusing about the casino debate is I've read all the Singapore debates, and it's the only debate to my mind where the MPs seem very encouraged to mention their faith. I'm a Muslim, I don't believe in casino. I'm a Hindu, I don't believe in the casino. I'm Catholic, I don't believe in casino. I'm a doctor, I don't think it's a good idea. right? It's quite funny because you'll never find any mention of religious affiliation in any other debate except this one. And the government, I think, encouraged this to show the religious community that, hey, their considerations were, not ignored. Okay, so religion is allowed in the public square, but if you are a religious leader, you are asked to be circumspect from the pulpit, and we have no religious-based political parties. In fact, our electoral system is organized such, through a multi-member system, that it will be impossible to have all Muslim, all Christian, all Buddhist group. Okay, it's impossible. You need to actually institutionalize multi-faith coalitions, or multi-ethnic coalitions within the government structure. Okay, I know I talk really fast, great apologies. I always try to stop, but it never works. As far as cults are concerned, in Malaysia, the government actually cooperates with the religious authority to regulate religious sects, like Al-Akam. When it comes to Singapore, to Al-Akam or Falun Gong, the government says we have no theological views. The only time we will regulate these groups if they cause public nuisance or breach any public order regulations. They will not themselves comment at all on theological viewpoints, because they're a secular state. The Singapore government also likes to cooperate with religious groups, particularly in the context of welfare delivery, as well as, building strong families. So even though two casinos were built outside a lot of religious groups, the government was very reconciliatory and said, please cooperate and, help us contain the fallout. So the government actually does give tax grants and free land to religious hospitals or religious education institutes, because it, in a sense, plays into government ethos. We don't have a welfare state, so it is necessary sometimes to protect people who fall between the cracks. So insofar as charity is concerned, the government is very happy to cooperate with religion. Alright, so there are free clinics. For example, the British Free Clinic, they must treat everyone, but Buddhist values also come in because, quote, they will not treat patients with venereal or infectious diseases or patients injured or wounded because of fighting. Okay, so they are clinic open to everyone, but they won't treat all possible diseases. Okay, religious freedom, as I've already mentioned, freedom of conscience is absolute in Singapore. There's no issue there. You will even find that we have what is known as the Islamic Religious Council of Singapore, and they give sermons every Friday. And if you go to the website, what is interesting is the nature of the sermons, and we'll only highlight one. Basically, it stresses that Islam is a religion of toleration, and there is no compulsion in religion. If you're a student of Islamic law, you notice that it's subject to many kinds of interpretation. Okay, so this is, if you like, the state-approved interpretation, because the Islamic Religious Council is a statutory board. It's a statutory board. There is some involvement of the state in appointing or confirming the appointment of the mufti and various other important religious personnel. Now, this is something that should be very familiar to Europeans, which is the wearing of religious dress in public. In Singapore, it comes down to the tudung or the hijab issue, which you're all familiar with. In Singapore, and don't forget, Singapore is a country where the government tends to not like rights litigation very much. It likes to sort things out dialogically or through quiet diplomacy. But in 2002, what happened was the parents of 4 primary school girls who wanted to wear tudung or hijab into school were told that they violated school uniform policies and they were suspended. So there was a lot of talk that this is a violation of religious freedom, but the government eventually said that it's the common space where we want to have a religion-free zone, if you like. So the mufti, who is the highest religious official in Singapore for Muslims, basically weighed in and said, yes, the hijab is very important, but so is education. Right? So while you're in primary school, before you hit puberty, just focus on studying. Once you hit puberty, it's okay. All right? The PM also said the policy is not written in stone, but as it is in Singapore, we need to have a common domain. Now, there's a bit of inconsistency here, because the Sikhs are allowed to wear their turbans, but they're not allowed to bring their kampans. And this is largely because the British allowed this. So sometimes history precludes a strict application of equality provision. Right? So again, this is what I mean by pragmatism. Right, because you want to minimize upset. So it's pointed out that you can wear your turban, but they can't have a kapan. So everybody is living in that living, right? Everyone is compromising to that extent. This year, recently, there was a huge debate on whether or not Muslim women in the police, the armed forces, and nurses should be allowed to wear hijab. Basically, the Muslim minister actually said, no, we have to work this out incrementally. We've got to do this step by step. And you can wear it in any other job. You can wear it in university. And let's not forget, the Speaker of Parliament is a Muslim, and she basically wears a hijab or tudung to Parliament. I know in Turkey you can't do that, right? I've read somewhere, I could be wrong. But in a sense, you can see that again it's a pragmatic policy. You can't wear it in school. You can wear it the moment you're out of school. You can't wear it when you're doing your nursing duties. You can wear it off duty. All right, and very importantly too, if you live with religious minorities, we have great debates over what food should be served children in primary schools. There was a school teacher who was a Muslim who banned char siu bao, which to a Chinese person is a pork bun, which is a very, very dear delicacy to most Chinese people. So there's a big hoo-ha because the parents are very disgruntled about it, and eventually the Ministry of Education had to lay down an edict saying, you must have halal food, of course, right, in schools, but you also have to have non-halal food. It is not neutral to ban non-halal food, which I think is a correct interpretation. So the whole point is to have public schools to be sites not of assimilation, but of integration. But there are other exemptions which are not allowed. While Muslims enjoy a certain degree of cultural and religious autonomy, this is not allowed to other groups where they're seen to threaten national security, most importantly the Jehovah's Witnesses, because Singapore has a compulsory military policy for all men between the ages of 18 and 20. So when the Jehovah's Witnesses cite the Bible or their Bible in court, basically these arguments are all rejected. And it's been said clearly by the Military Court of Appeal, the conscientious objection is an idea that does not apply here. So when you come against the might of the state, when it comes to national security issues, the courts are very resistant, right? So what is interesting then is this. While we think of rights as trumps in liberal constitutions, in a very unfortunate part of Singapore's history, public order was considered a trump, right? The courts basically said the sovereignty, integrity, and unity of Singapore are the paramount mandate. Everything else, which runs counter to it, must be restrained. This is a case in 1994. Singapore has changed a lot since 1994. We're hopeful that this kind of jurisprudence will never emerge again. Okay, this is the bad old day of the authoritarian state and Asian values. Okay, so basically, you will find that when the liberal courts may invoke the spectre of the Leviathan state, Asian courts back then invoked the spectre of the anarchic society. If we allow too much freedom, society will turn to chaos, which is also as extreme as a fixation just on one person's rights. Okay, sorry, I'll try and speed it up. Okay, right to propagation. We actually inherited the right to propagation from India. And I've studied the Constituent Assembly debates. I'm not an expert on India, but I've read it out a bit. And it's interesting that the people most enthusiastic about the right to propagate were actually a minority, the Christians. They faced a great deal of Hindu objections because there was a sense of, the British colonizers, tried to homogenize us. But there's also a political issue that if you allow Christianity or conversions out of Hinduism, you lose your lowest base, the Dalits, the untouchables. You actually lose a power base. Let's not forget that the Ambedkar, the father of the Indian Constitution, was a Dalit. He converted to Buddhism. Right? So basically, ultimately, India came to the conclusion that a secular state must tolerate our religions, and the compromise was this. There is no right to forcibly convert anyone to any other religion, but you have a right to propagate. You think about it, this is nothing more than religious free speech and viewpoint diversity. It's a laissez-faire model, right? Everybody should be able to hear and choose from a variety of religious offerings. Okay? In the Singapore context, even though it is a religious, it is a constitutional right, the soft law seems to say it must be exercised very sensitively, particularly when the Muslim community is concerned. So they said that you can become a public order threat when someone, an unrestrained preacher, pouring forth blood and thunder, denouncing the followers of other faiths as misguided infidels and lost souls, may cause great umbrage to ethnic communities. And when you consider public order in Singapore, you have to consider the mantra of racial and religious harmony, which I consider a quasi-constitutional norm. Right? So there's always a fear of disrupting social harmony. So it seems in Singapore that you can propagate, but the government keeps an eye on the numbers of converts. It says, if any religious group in Singapore seeks to increase the number of its converts drastically at the expense of other faith, then you're going to have pushback from other groups. So incremental increase is okay, drastic increase is a cause of government concern. I'll skip this part, it's not that important. Let me speak a little bit about legal pluralism and religious laws. As I mentioned, the Constitution actually has required the enactment of the Administration of Muslim Law Act. In Singapore, we have limited Sharia law as well as religious courts to deal primarily with personal law, marriage, divorce, property, inheritance laws. When we signed up to CEDAW, for example, this is important for human rights lawyers, a huge reservations are placed upon CEDAW because as far as religious minorities are concerned, in Singapore, for example, the Chinese were forced to discontinue concubinage or polygamy. in 1961 when the Women's Charter was passed, but a huge exemption was carved out, and Muslim men are allowed to enter into polygamous marriages, though Muslim women are not necessarily very enthusiastic about this. Right, so it's interesting to see, this is always a matter of issue before the CELAW committee. Alright, so what is the special protection? Well, in Singapore, because we had to have a lot of urban resettlement, and a lot of Malays used to live in what is known as kampongs, or rural areas. So they were forced to move into urban areas. So to placate them, the government instituted what is known as the one mosque, one new town policy, whereby they will give the land. Land is prohibitively expensive in Singapore because it's so small. So the idea is the state will give you land, but you have to raise the funds to build a mosque yourself. The exemption that applies to polygamy, the Women's Charter, and even during the SARS policy, when Singapore was hit by the SARS epidemic in 2003, the protocol was to immediately cremate the body. But you can't do that for a Muslim. So the protocol was if a Muslim dies of SARS, you must wrap the body, because they must be buried the day they die, in a double body bag and then immediately interned. Okay, so even in matters of public health, there is concession to Muslims. Right? Accommodation, every Friday, they are allowed to go off to pray for 3 hours. We and NUS can't have any classes between 1 and 3 o'clock on Fridays, and that's an accommodation. If you do national service, there is a separate halal military cookhouse, where we're told the curries there are much nicer than the Chinese cookhouse. We have the Islamic Religious Council, which deals with things like halal certification, dietary laws. They manage the Hajj to Saudi Arabia. They collect tithes to zakat using the state structure. I might add that there was an interesting case in the Philippines, whereby the Office of Muslim Affairs also issued halal certification. Right? It was effectively part of the executive branch, and it was considered to be a violation of state and of church and state in the Philippines constitutional order because of the model of religion and politics over there. But in Singapore, it's considered completely okay. All right. The last point I'll raise here is this: that when it comes to laws that the Muslim community is uncomfortable with, particularly organ donation laws, the government doesn't impose. You must opt in like the rest of us. It actually took about 15 years to try and evolve consensus within the Muslim community. And basically in Singapore, it's a presumed consent model. If you die, you can harvest your organs. But the Muslims are always kept out of it. Now they've been included since 2008, but they can opt out if they don't like it. But the idea was that they were trying to get the whole community on board, very, very wary of top-down approaches. Okay, my last point. Don't worry, I'll shut up soon. Racial and religious harmony, because it is important. Public order is about the absence of chaos. Racial and religious harmony is very important because harmony is different from order. Harmony implies a quality of relationship, which means that the government sometimes avoids rights-based approaches or law-based approaches because it wants to seek to reconcile the communities. I call this relational constitutionalism, which is fixated on the survivability of the relationship. Because right litigation is extremely adversarial. You destroy relationships, and that doesn't cause harmony. So the idea is to try and get people together through a dialogical model to sit down and talk things out. And there are actually laws and parts of the Constitution which promote dialogical forums rather than judicial settlements. So just let me say a little bit about that. This is the interesting part. Okay. Here are the threats to religious harmony in Singapore. One is inter-religious fervor, which is aggressive proselytism. Secondly is the use of religion to subvert the state. The most famous instance is apparently 1987, when a bunch of so-called Marxists, I don't really personally believe they're Marxists, supposedly wanted to subvert the Catholic Church to bring about a Marxist state. But in the demise of communism, nobody really believes that Marxism or communism is a big threat in Singapore anymore. Last but not least, religion and politics, which is the notion that we need to be very careful not to have the American culture wars. We want to keep things relatively on an even keel in Singapore. So the idea is, to be tolerant, to be moderate, and to keep religion and politics separate. But that is just rhetoric, because how can you define religion and politics when they overlap all the time? So it's dealt with in a case-by-case basis. Alright, so I think I'll stop here, but I'll just discuss this, because I spent time drawing this pretty diagram, and I want you to have a look at it. So here are the three approaches, if you like, I can discern from Singapore practice. Sometimes the government will be punitive. This often comes out through our sedition law, because sedition is uniquely defined in Singapore, not only as a treason against the state, but causing ill will between races and classes. And the word races and classes has been liberally construed to mean religious groups as well. So there have been two cases in Singapore. One would involve the internet. So basically, the constitution applies to the internet in Singapore. What happened is a blogger got very annoyed with Muslims and put a picture of a pig's head next to a halal logo, and it caused, a lot of like a stir on the internet. And the person who did that, the racist blogger that they had least known in 2005, was charged with sedition. Okay, that means you're fined and you could be in prison for up to 3 years. Right? There have only been two cases in Singapore. I don't have time to share it, but I have written a chapter for people who are interested in that. There's also a penal code which provides for wounding religious feelings. It's never been invoked to my mind. As far as palliative is concerned, pacification, there have been instances after great ethnic or religious conflict where the government has actually initiated an informal dialogical process to draft what has become known as the Declaration on Religious Harmony. Again, it's non-binding, but the idea behind it was at this time when social tensions were at apex, to get all the religious leaders together, to get them in the same room to talk and to come up with a statement of hospitality values, we shall protect each other kind of thing. Right, that's a big deal in the Singapore context. Last but not least, most uniquely preventative. This is something perhaps that the rural constitutions would get upset by. We have preventive detention laws in Singapore. We've always been criticized by America a lot, but in the aftermath of 9/11, America seems to shut up quite a bit. So we have what is known as the Internal Security Act. And if you cause a threat to national security, you can be preventively detained for up to 2 years. The government actually thought this was too draconian, so we have a very unique law, which was enacted in 1989, called the Maintenance of Religious Harmony Act. What it allows is it allows the minister to issue restraining orders on a religious leader or someone inciting a religious leader to do several things, including causing ill will between religious groups. These are non-reviewable. Alright, so this is an attempt to shift things out of the courts into the realm of politics and diplomacy. This is important because whenever religion has come to the courts, it has historically at least, the Maria Hertog riots caused civil disorder. The Maria Hertog riots is a very interesting case. It was about a Dutch girl in Malaysia who basically, her parents lost custody of her because of World War II. When they came back to find her after World War II, they found that she had been raised a Muslim by a Muslim woman. So they wanted to take her home to the Netherlands. And it was a simple family lawsuit, and it caused riots and deaths. So the Singapore government is very wary of religion, those kind of religious issues going to the courts. So they prefer the quietly approach, right? That's whereby you can sort things out dialogically, promote reconciliation rather than an adversarial ethos. All right, I'll stop here. Thank you very much.
Thank you very much, Professor Theo, for your insightful presentation on the Singaporean approach to deal with multiculturalism and diversity, religious diversity. Before I open the floor for questioning remarks, please allow me to summarize briefly, really briefly, both papers and give a short comment and then raise the question. Start with Judge Barnage gave us an overview about the interesting development of the Catholic Church in Croatia. Started, if I understood correctly, started with the policy of privatization of the Catholic Church and the exclusion of religion from the public sphere. And then it went on with a politics of politicization of religion and the Catholic Church, and now it ended in a what we could, if we use the title of the conference, it ended up in a relationship of competition right now. Let me say so. I find it very interesting, and my brief question would be also with regards to what Professor Theo said. Is there any approach in Croatia to resort to that kind of, how to say, management of religion in terms of we go back and we do not interfere in questions of values, but we go back to being a manager of this problem on the side of the government, on the side of the state. May I?
Yes, please.
And that would lead me to Professor Theo's presentation.
question on the concept of the sectarian concept and approach. It seems to me that you mentioned itself that the government is trying to manage and to order, and thereby avoiding positive messages in terms of values binding society, resource to a position of a manager, and as long as harmony exists, and it's fine. My question would be: is there any positive notion of what harmony is, or is it purely a functional, structural, procedural notion? Thank you.
Thank you very much. As regards to any approach to management of these present conflicts, I really have to say that I'm not very optimistic at this moment, because as I have said to some of the colleagues, on the 1st of December we will have the constitutional referendum on the issue of marriage as a union of a man and a woman, which is actually the cause of lack of dialogue between the religious community, dominant religious community in Croatia, and the government. It started all with the legislative action from the side of the government, which wanted to equalize the homosexual couples with the marriage, and of course, it confronted the basic traditional value in the Croatian society, which is deriving from this Roman Catholic affiliation. So I think the government was not ready to very precise organization of this conservative side of the society, and they proceeded with this issue and came to the parliament with 10% of the voters wishing to have referendum, and they succeeded in it, and they will have it now on the 1st of December. And now actually Croatia is in a crisis, in a kind of really moral or ethical crisis, because you have society divided on two sides. One of them supporting church and its vision of marriage, and another one supporting secular state. So I didn't see any dialogue between religious community and the government. These Catholic scholars say actually that the church at the moment is in voluntary exile, because they cannot approach to the government. But I think they cannot approach to the government exactly because of the issue that Professor Zuchhuber, did I say correctly? Zuchhuber, excuse me, I'm sorry, excuse me, Professor Johannes said that the church lacks actually the acceptance of the dignity of the differences, and that's the main obstacle for the dialogue at the moment. And they do not actually proceed in that direction because they stop in their sides, and no one moves, toward to each other.
The question to me was about whether harmony was just procedural or substantive. Let me just give an example to illustrate. I didn't have a chance to go into that. Well, a couple of years ago, there was a Christian pastor who put up a sermon on his church website, which was critical of Buddhism. What happened was there was a lot of upset again on the internet. What is interesting about it is at least the government, for all intents and purposes, was in the background. We in Singapore are very used to the government being very much hands-on. But when you're dealing with relationships, it isn't due to order people around. So what happened was that it kind of seemed to be in the background, just to make little noises here and there. The Buddhists and the Christians reconciled. They were on the front page of the newspaper. It was very, very public. And the government then said, see, this is very good that you can all, be grown-ups and kind of forgive each other and reconcile each other. You can have a right to evangelize in Singapore, but you must not denigrate any other faith. You must be sensitive about it. What is interesting about it is the government only approves after, it's like a fait accompli. After it's all done, it comes in and says, this is a good idea. So I think harmony in this context is the government letting them have the space to work it out. But I think they are pushing things in the background. And whether it's substantive or not, it's the notion that the religious leaders come out and say, well, we've been talking, we'll continue to be in contact, we understand now that it's important to be sensitive. And the way it's all sealed is this, because a lot of these Buddhist Christians tensions do flare up in Singapore. So let me see if I can show you a picture here. I found this quite, amusing. I found it amusing. Yes, I tend to have too many things. For those who can read Chinese, you see the word Tangge. But what happens is this, the Taoists get upset with the Christians, they kind of like talk it out, and then very, very publicly, the press will be there. We only really have one newspaper in Singapore anyway, so this is very significant. Okay, we have three. They will get together and they'll sing Hokkien songs, right? And basically, the guest of honor will be the Prime Minister. So the idea is to get the religious leaders to come and, it's like harmony through singing, literally and metaphorically. So the idea is, it shows to Singaporeans they've forgiven each other, they've moved on, and the Prime Minister is there to kind of like give his imprimatur of approval. So this is how harmony works. It's the government taking a backstage rather than front stage.
Thank you very much. Now I open the floor for questions. Dr. Bushes.
Thank you. Wojciech Brzozowski, University of Warsaw, Poland. Well, I'd like to start with paying my sincere compliments to both speakers for these brilliant and energetic contributions, which were both incredibly rich in information and also made me realize how much I need to learn about preparing PowerPoint presentations. Apart from being astonished, I have actually two questions to our Croatian guest. And the first would be, well, your remarks in general struck me as very adequate to describe the Polish experience as well. And it seems that the similar religious structure of the society goes hand in hand with similar problems. And this is not only about the strictly religious problems, but also about the recent developments that you mentioned, like, for example, the issues of the same-sex marriage. However, my questions would be, firstly, there is a concept of which has existed in the Russian political thought about the idea of symphony. The idea of symphony is something that is a concept that describes the desired relationship between the state and the Orthodox Church, and it's about like mutual favors. It's about some form of symbiosis, which is based on the church praying for the prosperity of the political authorities and ensuring the social stability, and about the state returning the favor by means of, well, let's say, legal stability and financial aid and so on. This idea of symphony seems strikingly, let's say, adequate to describe the current relationship between the Polish state and the Catholic Church, and it seems to me that it could be as well used in the Croatian context, even though, of course, it was elaborated on the base of the relationships between the state and the Orthodox Church, which is something different, which is autocephalous, which has no, let's say, international headquarters like the Holy See. But still, do you see anything in common between this Russian idea of symphony and the recent developments in this alliance, or, as you said, if I remember that correctly, mutual affirmation of the state, of the ecclesiastical body and the political authorities? That's my first question. I'll try to keep it brief when asking the second one. The second one would be about the concept of division of powers, because it seems to me, and it seems to me even more when I listen to you, that the traditional trias politica and the traditional idea of division of powers needs to be redefined because of some advances of the political role of religious denominations. That is because, in many cases, the political mobilization of the followers of a dominant church, which is present in Poland these days, results de facto in an accumulation of power. And so even though the traditional concept of division of powers should be applied just to the political authorities and to the public powers and not to the non-public actors. My question would be, don't you think that we should redefine or reshape the very idea of division of powers, taking into account this growing role of the religious denominations? This issue has been so far, as far as I know, has been mostly discussed by the social science, not by the legal science. But there are several contributions by philosophers or social scientists like Professor Beckenförde or, for example, Rafael Diaz-Salazar. So how do you see this issue? Thank you very much, and I guess I should pass the microphone to Professor Martin Storon, right? Or some. Is there anyone?
Professor Helbert, maybe give opportunity to answer first.
Thank you very
Okay, thank you.
Thank you very much for the question. I know that the situation in the Catholic Church in Poland was really contributing to democratization of the society, which did not happen in real sense in Croatian society after 1990. It was actually that politics attracted religion, and it became its essential element for the legitimacy, as I have said. So suddenly you had really a blossom of these religious feelings, and the religion came back really on a big door to the public sphere. What happened actually that this situation with the Russian concept of the symphony was going on between 1990 and 2000 because of the linkage of the Catholic Church with the right-oriented party. And that is still actually the objection and the obstacle of the Church now after the 2000, when it came to a change of the power, because we had one period that it was on the power the link-oriented party, then again the time when the right-oriented party was on the power, and now again we have the link-oriented party. But it seems that this symphony is problematic because I didn't notice that the Church succeeded to be critical over both of them, and that's why they do not succeed actually to balance their relationship toward the power in general. So all the time, it seems that there are expressions of their wishes actually to be critical about certain things seem to go right, seem to go very much to what is proclaimed by the right-oriented party. So they do not succeed at the moment to make this symphony possible, and they are aware of it, and they actually justify it with the expression that they do not have Christian scholars defend themselves, that they do not have the political or social or cultural elite that would promote Christian values in the society, and so contribute actually to the reassertion of religion in and its social influence. So with regard to the concept of division of powers and traditional division of powers in the political powers, I really don't know how it would be possible if the powers, now that it is, would not equalize all of the religious communities, regardless which one is dominant or not. Because we always considered that Croatia is a multicultural society, in spite of the fact that 85% of them claim themselves Catholics. And I said in my speech actually that this affiliation, this alliance to the Catholic Church actually contributed to stagnation of other religious communities. And I think that current power wants to equalize this position, and the Catholic Church actually is reluctant about it because they do not want to lose their privileges. So at the moment, I don't see how it would come to this possibility of the division of powers where religion could find its place? I don't know whether I succeeded to answer partly. Okay. Thank you.
I have three questions in queue. We are facing tremendous time problems, so I would like to collect the questions and ask the presenters to answer them in a row. So first, Professor Lebua, please. Asked to hold it brief.
Thank you so much, Professor Dukondi. First of all, I'd like to say my gratitude for the center for your provoking and enlightening presentation. My name is Sarah Susetti from Faculty of Law, University of Indonesia, Jakarta, Indonesia. My first question addressed to Justice Lakikabenik. If I'm not mistaken, that the Balkan Wars in 1992 to 1996 is among of the reason or the trigger are religious and ethnicity problem in Croatia and Bosnia and or in the former Yugoslavia. So since then, the former Yugoslavia then turned into different modern new states like in Croatia, Bosnia, Serbia, and other countries. How to manage the religious minorities in each countries? Let's say in Croatia, how to manage the Muslim minorities or Christian minorities, or in Serbia, how they manage the Muslim minorities in Serbia, or even in Bosnia, how they manage the Serbian minorities or Croatian minorities, because it's not that easy to manage or in the aftermath of the conflict, since the religious and ethnicities are amongst of the trigger of the conflicts. Secondly, just to Professor Theo Lee An about how the Singaporeans and Singaporean government define the Malay. Is it similar with Malaysian, or was the government define the Malay or different? Because as far as I know, that Malay, not all Muslims in Singapore are Malay. Maybe some of them coming from Bugis or from Sulawesi, or maybe from Javanese, which is presently part of Indonesia, or maybe from Sumatra or any other countries in the world, from India or whatever. So how to define Malay? Do they have to speak Malay, or do they have to having like Malay culture and must be Muslim? Secondly, why there are no religious-based political parties in Singapore? Because in comparing with the situation in Indonesia, there are Christian political parties, Catholic political parties, even though they are not past the electoral threshold, but there are political accommodation for a minority in Christian and also in Catholic. And even in the last election and also the next year's election, we have local political parties in Aceh. There are 3 political parties will run into election in next year. So these are my questions. Thank you so much.
Thank you. Next is Professor Martinez Turan.
First of all, allow me to give my compliments to the 2 presenters. They have done an excellent job like the presenters in the previous session. And actually, you have raised the level so high that it's going to be difficult for the rest of presenters to keep up with it in the rest of the conference. Among the many interesting topics you have mentioned, I pick up one for the question to Justice Baggage because of its connection with some Spanish issues, and also because the reasoning we use to solve this problem may be applicable to a number of other issues concerning the relations between state and religion. I refer to the issue of that religion teacher that was not fired, I would say, was deprived of their ecclesiastical permission to teach religion in your country. And before I pose my question, let me make something very clear. I don't like, and I don't agree with many of the decisions taken by bishops in my country. This is no surprise. I dislike many of the decisions taken by state, national, local and regional authorities in my country. But once said that, I think that here we are not speaking, the crucial issue is not agreement or disagreement with the decision of the bishop, but rather the issue of competence. Who has the legitimate competence to decide on this? And my question is, when a person is teaching religion, in this case Catholicism, on behalf of a particular church, wouldn't it be a violation of the religious neutrality of the state to attribute the competence to decide who's appropriate or not appropriate to teach religion? I insist, it's not a religiously neutral education. It's religious instruction on behalf of one church. Who else, apart from the church itself, can decide who's appropriate or not? Thank you.
And now our next Professor Dr. Zahuba.
Thank you, and thank you to both speakers. I can only agree with what other people have said. These were two incredibly insightful papers. My question, though, is specifically to Professor Lian. I really liked your idea or your reference to pragmatic secularism. But I do wonder whether or not many other secularisms, perhaps all secularisms, are much more pragmatic than we often think. Is this just something that happens in Singapore, or isn't it rather the case that, for example, many Western countries that think of themselves as perfectly secular really are only so because they choose not to look at certain things that actually violate the principle of secularity? And so in a way, what you're saying isn't what you're saying, that on the ground, religion's just there, and whatever interest scholars of jurisprudence or constitutional law may have, in practice, people have to approach a pragmatic approach to these issues. Thank you.
Thank you very much. I have here one more written question. It's submitted to Professor Leo, but I cannot clearly read the handwriting.
Very much. With regard to the first question and the Balkan Wars that lasted from 1991 to 1995, I will have to tell you actually that the ground of the war could be said, this ethnicity issue. In Croatia, the 85% of the people are Croats, and about 10% of the people were Serbs. So the starting point in independence, in separation, was actually that Serbs are not anymore equal as they were equal in the former Yugoslavia, but they became minority. And that was something actually that disturbed very much the Serbian nationals at that time in the former Yugoslavia. As regards to Bosnia and Herzegovina, you have to be aware that they do not have minorities. They have the constitutive nationalities. They are Serbs, they are Croats, and they are Muslims. Actually, today they are Bosniaks. So they are not treated as minorities, and they are all equal on the constitutional level. With regard, with the issue, the position of the Muslim minority in Croatia, for a certain period of time, they were not in the preamble of the constitution. They were not alleged as the minority, and it came to a change of the constitution when even Muslim minority become as accepted ethnic minority in the Republic of Croatia. Their position as a religious community is actually the position of all other religious communities in Croatia, which means that they had the obstacles for the religious education, they had the obstacles to have the seats for their profiting priests, and all other, issues that were not clearly set in the act of the religious status of the religious communities, but there are really progresses going on. So Croatia has a mosque in Zagreb, and the second one was built in Rijeka, and it was considered to be the most beautiful one by the architectural design in that part of the Europe. So it means the progress is going on with regard to Muslim minority and Muslim religious community in Croatia, but referring to other former Yugoslav republics, I really cannot talk because I do not know very well. Although I originate from Bosnia and Herzegovina, And I grew up in a multi-ethnic society, and I could say actually that it was a very multicultural society before the war. What happened after the war, I am not very much acquainted by that. So this is with the first question. Regarding the second question from the Professor Perron, yes. When we reviewed the case of the religious teacher, we really very much relied actually on the Spanish experiences and on the Spanish way of dealing things and amparo against the religious teacher who was also fired because of some aspects. But unfortunately, what happened is that they would not, these aspects from your experience were not accepted by the majority of the Constitutional Court, majority of the members of the Constitutional Court. With regard to the Concordat with the Holy See, the mandate to give, actually the power to give the mandate is on the side of the church. And there is no reason, because of no reason, they can withdraw mandate, not even giving the explanation to the state why they do that. So as soon as the religious teacher is withdrawn, the mandate is withdrawn, he or she loses the right to be religious teacher at school. The problem of the state was actually that they had the occasion to make actually regulation, like in Spain it was done, in a way, to make the regulation on the ways how certain religious teachers may enter public service or how they could be fired if they lose the mandate. So this was not done at all. And it came to a situation as soon as the church withdrew the mandate, he actually could not work anymore because simply said he had no license to work in the school for teaching without this mandate, because the agreement is clear about that. Nobody who has, when the church withdraws the mandate, that person may not teach Catholic religious education at schools. So that's why two of us thought that it came to a kind of blurring, dividing line between the state, between the separation of the state and religion, because it seemed that the sole competence on the side of the church actually interfered into the public service. So it's still the competence on the side of the church to decide freely who can enter the school or who can go out from the school. And the church the state accepts it as it is said. So this is it. Okay, thank you. Thank you.
Okay, I have a written question. I'll answer that first. Have you had any instance in Singapore where a religious tradition was winning more converts than any other tradition at such a fast rate the government became concerned? Yes, actually. In the 1980s, there was a concern that the Christians were growing too fast. So the government actually commissioned a report to see, what they call the religious switching report. And there was a bit of discomfort, but hey, religious evangelism is a constitutional right, so what are you going to do? So as long as, the real concern in Singapore, to be really, really frank, is the Hindus always feel a bit insecure, but they pretty much stay very constant at 4 to 5%. It's the government's concern is with the Muslims, right? That if they feel as though their community is being threatened by attempts to convert them, there is a fair amount of disquiet. So I think what the government does is it can't do very much, but if there is it does prefer an incremental increase rather than a drastic increase. So long as I think the Malays are not being upset, I think the government just manages things quietly. It can't really step in and change. How can you interfere with a person's free choice to religious affiliation or not to religious affiliation? I would add, in the last census in 2010, the two fastest group, or the group that is declining the most, are the Taoists. But the Buddhists, as the majority, are still increasing. This is because Buddhism is seen to be modernizing, whereas Taoism is seen to be mystical and superstitious. And in modern Singapore, people tend to go for the more rational religions. But the two groups that are growing the fastest are the Christians and the atheists. Okay, so that's currently they're about 18 to 70% each. So the government only is primarily concerned with upsetting the Malay community. At least that's my personal view. Another